Hey everybody, great to see you. It's Danae here to help with your employment tribunal questions about grievances, all kinds of stuff like that. And I will just wait for people to join. Hey Revive, great to have you here. I am live on both YouTube and TikTok, so I can take questions from either. I've got you all loaded up here, ready to take any questions that you have about employment tribunal grievances, the ACAS, early conciliation process. That's a big one. I've been hearing a lot about that lately. Settling with your employer, if your employer maybe has given you a without prejudice offer, or if you want to reach a settlement with them. Those are all things that I can help you understand, answer questions about, all that kind of stuff. And I'm just going to pull up the live here on my computer so I can see your questions and I can answer them quickly. But if you don't know who I am, or if you haven't met me before, my name is Danae, and I have a platform called VALA that helps people represent themselves in employment tribunal. Basically, about 30%, about a third of people in the employment tribunal represent themselves, usually because they can't afford a lawyer, because a lot of people can't afford a lawyer. And so I've built a platform that helps people actually manage that whole process, understand what's going on. And I often do lives here to help people understand how to actually navigate the process, find out how we might be able to help them. But yeah, the platform is completely free to use. It is at vala.uk. And I'm here most days to try and answer any questions that people have if they're stuck in the tribunal process, the ECAS early conciliation process, and if they want some support to, just understand what their options are, what they might want to do, etc. So yeah, lovely to see you all here. And if you have any questions, that is why I am here to answer any questions that you have to the best of my ability. I'm not a lawyer. I'm a technologist. I built this platform with my team because I was honestly pretty pissed off about how nobody seemed to be able to do anything about injustice at work. But I've learned a lot about employment law along the way. And so if I can answer the question, I will. And if I don't know the answer, I will do my best to point you to an answer or to one of our team who will have even more experience. So yes, feel free to ask any question that you have. And in the meantime, I will talk you through the best way to handle poor leadership plus bullying without grievances. That's a good question, FM. So typically on this channel, I try to focus on things that what I help people try and do. Thank you. What I help people try and do is understand the potential legal aspects of what's going on so that they can use any legal leverage that they have to hopefully get the situation resolved even more quickly. Because often it's hard to get your employer to take you seriously, right? So a lot of what I do on these lives is I help people try and understand if there is a legal aspect. So with that in mind, the first thing I would look at, FM, is I would be looking at, I've got a video a few rows down called "When is Bullying Illegal?" There are some times that bullying is not just bullying.
I found this on the web.
Bullying alone is bad enough, right? It's awful. I've been bullied at work and it nearly broke me. But bullying itself is not a legal term, but there are times when bullying can be illegal, particularly if the bullying is happening because of a protected characteristic, like your age, your sex, your race, or if you've worked at a company for over 2 years and the company is essentially trying to bully you out, then that could potentially be constructive dismissal. In both of those cases, however, a grievance would absolutely be the right next step to take. And there's a reason why you go through a grievance process, even if you think it's going to fail, especially if it's relating to protected characteristics. Because if you want to maintain your legal leverage, and that's what I do a lot of teaching about on this channel, is I help people understand if you want to maintain any legal leverage, if you want to create that legal leverage, what you need to be doing is making steps that you think a hypothetical tribunal judge in the future would think is the right thing to do. And the right thing to do is to raise it informally first as a grievance and then formally as a grievance if it's not dealt with. And if you do that and your employer still doesn't do anything about it, if there is a legal element, it means that you have a much stronger case. So generally, I would recommend grievances. And the other thing is, if you're raising a grievance about potential discrimination, and remember, there are 6 types of discrimination. A lot more is called discrimination than we kind of think of at the top of our head. If you're raising a grievance about discrimination, that's called a protected act. And if your employer punishes you for raising a complaint about discrimination, then that would be called a detriment of victimization. And victimization is also illegal. So often people will get discriminated against in one of the 6 ways, complain about it, and then the company will be like, oh, they're a troublemaker, let's sack them or let's take them off that project or whatever. And that's actually the thing that gets them in tribunal hot water in the end, because it's easier to prove. And oh, thank you so much, Mr. J, for the lightning bolts. Hey, Savvy Money Show, good to see you. I'm on YouTube and TikTok at the same time. So that's why if bullying does have a legal element, especially if there is a protected characteristic involved, then grievances, almost always grievances are the right first step. I hope that answers your question. Other people will be able to answer your question about how do I do it without a grievance, but I'm not the right person for that because I do try and help people optimize for that legal leverage, if that makes sense. Okay, so can an employer decide not to process your whistleblowing complaint, instead calling it a grievance? That's really interesting, CKB. That's interesting. So CKB, did they give you a reason as to why they did that? Because the first thing that pops into my head is whistleblowing is a very narrowly defined thing in the law. There are only, let's just look at it, whistleblowing criteria workplace. It can only be a whistleblowing claim, or it can only be technically called whistleblowing if it does, let me find it. So if you raise an issue that is about a criminal offense, someone's health and safety in danger, risk or actual damage to the environment, a miscarriage of justice, a company is breaking the law, or you believe someone is covering up wrongdoing. So those are the 6 criteria for whistleblowing. So if your employer said it doesn't fulfill those 6 criteria, therefore we're not going to class this as whistleblowing, we're going to class it as a grievance, then maybe, but that they should have given you that kind of justification. Let's see what you're saying. Let's see what you're saying, and then cover it up. Just seeing if you've said anything else about it. So if you so I've just listed out what the criteria are for whistleblowing. If you think it fits into one of those categories and they're pretending like it doesn't, then that is not like a good way to handle a whistleblowing. So yeah, like if you think it's whistleblowing and they don't get to decide that it's not whistleblowing. Only the tribunal can decide that it's not whistleblowing. And so if they're not dealing with your whistleblowing incident correctly, then you would want to first appeal. If they're treating it as a grievance, then appeal it and say this is whistleblowing. But then equally, you would want to make sure that you're looking at your ACAS early conciliation, you're looking at the whistleblowing legislation, looking to see if they are detrimenting you in any way as a result of the whistleblowing. So are they mistreating you because you have blown the whistle on this? And then going from there. There is a fantastic charity called Protect, who are a whistleblowing charity. So I would highly recommend that you go to their website as well and check out their whistleblowing criteria. And if you want to know more about like the grievance stages and everything else, how you could go from there, if you click on the free action toolkit in my bio, or YouTubers, you can find it on vala.uk action toolkit in the menu, then that will give you some more information as well. You're very welcome. Right. So has she been there less 2 years? They might want to avoid her having whistleblower rights. The thing is, you still have your whistleblowing rights even under 2 years. Your whistleblowing rights are day 1 rights. So you could blow the whistle on day 2 or 1, and it would still be legal. Hi, I love your content. Thank you, Kay. I appreciate you. Okay, let's see. What evidence do you need for a constructive dismissal case? Text, notes of meetings, witness statements, etc. Great question. And in fact, I've actually just taken some notes on this. Let me just see if I can pull it up. 1 second. I might have a little bit more that I can read out to you on this. Sorry, I've got too many windows open. So what evidence do you need for constructive dismissal? That's the question that we're looking to answer. Okay, I've got something to read to you here. Okay, hold on. Give me just a tick. Oh my goodness. I promise it's nearly there. Okay, so the basic description of constructive dismissal is that the employer, you have been forced out of your job by the employer. Now, technically, constructive dismissal is called constructive unfair dismissal. That's the full term. So let's just see. So constructive dismissal, unfair constructive dismissal is in its full term, constructive unfair dismissal is where there is a fundamental breach of contract and you resign because of that fundamental breach of contract. That's the kind of fundamental test of it. Now, normally it is a breach of the implied contract, the implied duty of mutual trust and confidence. So, for example, this means that they have behaved so badly that they have broken like the very fundamentals of what it means to be an employer and an employee relationship. And so and it doesn't have to be just one thing. It could be a series of things and then like a last straw kind of incident. And so the key things that you really want to show when you're doing that is, as you say, notes, contemporaneous notes. If you haven't seen my videos about contemporaneous notes, that's very important. But any notes that you have about who said what, when, etc., you want to look into that phrase of mutual trust and confidence and see examples of those. And then you also have to prove that that's why you resigned. So if your resignation letter says, I resigned because of this, then that's like a very good start. Otherwise, you need to show other evidence as to why you resigned, that the resignation was because of the breach of the contract, the implied terms of mutual blah, 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 trust and confidence. Does that answer your question about, so what I've just talked you through, that's the legal test for breach of contract. I hope that helps. So they breached it, you resigned because of it. And equally, the other thing about breach of contract, constructive dismissal, is that if you stay around too long after the implied breach of trust and confidence, then they might say that you have affirmed that that was okay. So like if you waited around for a couple of months and then resigned, then that would be a much weaker constructive dismissal case. Okay, so let's just see if there's follow-up questions on that before I go to other questions. What if an agency handled the resignation? Okay, so why not say hello? I have meeting notes and resignation letter and a subsequent meeting with HR. That makes sense. And why not say hello? In those notes, do you need, have you explained that the reason that you were resigning was because of the thing that broke your implied trust and confidence? So are you saying in those meetings or in the resignation letter, I am leaving because that will be very helpful. Again, you don't have to have a resignation letter that is as clear as that, but it does definitely help. Right. What's too long? Do I need to raise a grievance first? So no, constructive dismissal is one of the few places where if you can, like I said, you can have a ongoing thing, but then if there's like a last straw, then that triggers you resigning. That's okay to prove. But it is generally very good to show the other side, or to show the tribunal, that you're trying to work with the other side to get the issue resolved. So let's lay out an example, for example. One of the things that can count as constructive dismissal is if they keep taking your responsibility away from you bit by bit. And so let's say that, over a period of 6 months, the employer just keeps taking responsibilities away from you bit by bit, and you raise it first with your manager and they don't do anything about it. They give you the runaround, and then you're like, this is seriously not okay. So you raise a grievance about it and it's still not getting dealt with. And then at, month 5 or something like that, they then take away your title. They change your title to something ridiculous. And at that point, you're like, this is ridiculous. I'm resigning. I don't even have a job anymore. This is outrageous. That would have been the final straw. And so, but if you'd stuck around even after that final straw and said, this is ridiculous, I'm not going to take this, and then just stayed, then that would be a less strong constructive dismissal case. So it's all about the storytelling, basically. What was the final straw? What was the egregious act that they did that broke your implied terms of trust and confidence? And then how long did you stay after? Why was it impossible for you to continue staying? That's the kind of stuff that you want to kind of lay out. So let's just see. Not in letter, but in many meetings, and I've been giving no resources to do my job. And then when asking for support and the effect on my mental health, this specification was made smaller with unrealistic objectives. I'm working notice at the moment. So working your notice in a constructive dismissal case, working the notice implies that you can continue working there, if that makes sense. So it's not to say that it's impossible to win a constructive dismissal claim if you work the notice, but it definitely will come up if you're working the notice, because that, again, what constructive dismissal is quite a high bar to reach, because it has to be that they have made it impossible for you to stay, if that makes sense. Now, it doesn't mean that you, like, quitting without working your notice is the strongest constructive dismissal case. It doesn't mean that you automatically can't make a constructive dismissal claim if you do work notice. I think Tribunal understands we all have bills to pay, but yeah, I would look, if you haven't already, I would look at the Tribunal decisions website on gov.uk and look for some constructive dismissal cases so you can read the criteria that they are working their way through to determine whether or not it is constructive dismissal. The other thing is, if you want someone to give you an opinion on this, we have a merits assessment service. It's under the link in my bio on YouTube. It's under coaching services on the homepage. And that is where one of our coaches will have a look at your situation. You upload information onto our platform. They'll have a look at it. They'll give you an overview of how strong we think your case might be. And then you'll have a call to kind of talk it through. So hopefully that can help. Okay, so I've got a few questions on YouTube. I'll get those next. I promise I will get to all the questions. I'm so sorry. There's just loads of fantastic questions. You're very welcome. I hope you're okay. I'm so sorry you're having to deal with this. Why not say hello? Okay, YouTube. I think some KC. Oh, Russ, thank you so much. I love your content, and I'm a union rep, and your knowledge of employment law is brilliant. Thank you. That's high praise coming from a union rep, considering I'm not a union rep, nor am I a lawyer. I just really care about this. Okay, KC, I think some employers engage in such malpractice that the culture of bullying and abuse is so embedded, it hardly makes it worth it to proceed to internal procedures. Victimization and retaliation almost certainly will come your way. In essence, often the only way to seek redress or justice is to go to employment tribunal. So that's a good point, KC. I don't necessarily know that I agree with you, though, and not from a human perspective, because I completely agree with you from a human perspective. But if you think about like a strong case at employment tribunal, the strongest possible claimant case, there are a few circumstances where you don't need to go through the grievance process. One of them, for example, is if you think that you can apply for the protective award because you've been dismissed for a union-related activity or a whistleblowing activity. You would apply to go straight to employment tribunal within 7 days of being dismissed, because If you apply within 7 days, you can ask the tribunal to make your employer continue to pay you your wages whilst you're getting it sorted out. So there are some cases where you don't do the grievance process, but in the vast majority of cases, what the employment tribunal is looking for is that you have done your best to follow the ACAS code of practice, and that your employer has done their best to follow the ACAS code of practice, and that you've tried your best to resolve it without having to go to the employment tribunal. If, for example, you go straight to ACAS early conciliation without the grievance process and you win your employment tribunal case, the tribunal could reduce your award by up to 25% because you didn't use the grievance process beforehand. So it is worth thinking about. And the other thing is, if you have a really, really shitty workplace and they're going to punish you because of something, if you're raising an issue about whistleblowing or discrimination, remember there are 6 types, and they punish you for raising that issue, then they're actually just giving you more ammunition. Like, it is, at that point, it's like an evidence collection exercise, because they would have been victimizing you. You will be able to document it, and then it makes your potential claim even stronger. Now, obviously, that has a human cost. And so I'm not at all saying, this is what I recommend you go out and do. But from a legal perspective, from a process perspective, thinking about that hypothetical tribunal in the future, it is worth considering that perspective when you decide what to do, because you want to build as strong a hypothetical tribunal case as you can, so that you can hopefully negotiate at an earlier stage and just get the whole thing settled beforehand. Let me know. And Casey's saying, I'm do the grievance, but it is very likely to be a tick box exercise or it's ignored. Yeah, I completely agree, Casey. Like, there are so many companies. Yeah, and Casey's saying, actually, that's not what I meant. Well, that's useful for anybody who didn't know that, because that is a very common concept where people are like, why bother with this? I just recently did a video that said, your grievance is likely to fail. Here's why you should do it anyway. And I completely agree with you, Casey. It's a waste. Like, it's nonsense, right? Like, it's a waste that you have to go through a nonsense exercise because you know that the employer won't take it seriously. So yeah, it's ridiculous. Yeah. Okay, another question on YouTube. Let's see. Hi, Quietly Soulful. Good to see you. Savvy Money. I was fired from job of 32 years because of my disability. My goodness. I got a new job informing them of my disability and received great feedback until recently, after I passed my 3 months probation, and I sent them an email detailing what to do in case of a seizure. And then their attitude changed, and now I have a formal interview letter. I can't help but feel it's linked to my email, but I have only been there 4 months. Well, goodness, of course you think it's linked to your email. It sure as hell sounds like it's linked to your email. Did anything else change in the meantime? And what is a formal interview letter? What are they interviewing you about, Savvy Money Show? That sounds really sus. So I'll wait for you to come back and I'll answer a few more questions over on TikTok. Okay, so Sophia, my employer responded to my employment tribunal asking for the figure I think I am owed. Will they settle before employment tribunal? Good question, Sophia. If they're asking, then they very well may. It's very normal. There's a few stages where typically we kind of see an employer at least opening up the conversation to see what they're asking for. And one of them would be ACAS early conciliation. That's what that's designed for. And then the other time, typically I see after an employment tribunal claim has gone in, either the employer pushes back hard with like a strikeout application and an ET3 that says that, everything you've said is lies, and a cost warning letter as well sometimes, or they're like, you want to try and resolve this. But often they do wait until the preliminary hearing because they want to see how strong your case might be, and then determine whether or not they want to push it hard or not. And often they wait until the preliminary hearing because they want to see if they can get the whole thing thrown out. Because one of the really common tactics immediately after a tribunal claim is filed is for the employer to file for an application to strike out, just to try and get the whole thing thrown out. And if you want to know more about that, I did a video recently called how employers respond or how employers react to tribunal claims. And that will give you a better idea kind of what your employer might be thinking about at this point. But if they're asking for a figure, I would encourage you to engage with them in good faith on that basis. But if you do, like, if you want help with a figure, we have tribunal coaching. The link is in my bio, and the link is on the website under coaching services. And KC is adding to this, saying going to employment tribunal is as much a test of patience and perseverance as much as anything if you have a strong case. I completely agree, KC. A lot of it is holding firm when the employer tries to buffet you with all these like wins of horrible, like, we're going to strike you out, we're going to make you pay our legal bills, like all this nonsense. And often employers and their representatives will throw some really ridiculous things at you to try and get you to just drop the claim. That is one of the most common responses that we see. Right. What would be the figure if you have discrimination in work? Good question. So I think a few people are asking about this. What number do you want to go to? So if you have been discriminated against at work, one of the main financial compensations that you would ask for is something called the injury to feelings compensation, injury to feelings award. I just did a whole webinar on the Injury to Feelings Award. So if you want to know more information about it, there's the link to the webinar is in my link tree, or for YouTubers, it's on the events page of our website, and you'll see how to calculate injury to feelings. Thank you very much, No Name. If you have raised a grievance or you've been dismissed and you're trying to decide whether or not you want to go to tribunal, and you're trying to decide how much you might be able to win or how much you should ask for, then I would use our merits assessment service. That is where one of us will take a look at your case and give you kind of an assessment of how strong we think your case might be, how much it could win in tribunal, how much you might want to settle for, etc. So that's on our website under coaching and in my link tree under merits assessment. Okay. Do they name and shame employers after employment tribunal? I know they do it on illegal pay stuff. So all employment tribunal cases are publicly available, not the claims. So basically, if you make a tribunal claim and it gets to the preliminary hearing stage, then it will be on the employment tribunal decisions website. So it is public in that way, yes. But they don't have like a name and shame website. It's just that your name and their name will be there. And the details of the case, like, go and look at the employment. If you search for employment tribunal decisions, it'll be on gov.uk. Then you can see what's publicly available. Okay, so love that channels like this exist. Need it a few years ago, but thankfully was able to get away. I'm so pleased you were able to. Let's see what else. Hello, HR student here. Hello, I find your content very useful. Thank you. You're very welcome. Oh my goodness, Just Joe, it sounds like you've had a really tough time. So Just Joe, unfortunately, I'm not an expert on agency stuff, so I'm afraid I can't help you with agency specific information. It's something that I need to look into and get more clued up on because I've had quite a few questions about it. If a colleague keeps complaining that there are too few of his nationality, is that illegal? This face is my "are you kidding me" face. So please tell me. Sorry, I'm a little like vibrant vibe. I'm a little kind of blown away. Probably, yeah. Especially like. Can I have a little bit more detail? Vibrant vibe, maybe the ethnicity of the person who's complaining that there aren't more of them. And are they saying anything specifically about the people who are there who are not of that nationality or ethnicity? Yeah. And do you feel like it's targeted at you in any way? Or are you one of the people who is not part of that nationality or ethnicity? Okay, Katie, while you're answering, Katie, can I be sacked being on long-term sick due to mental health and stress caused by work? Good question, Katie. So your employer, if you have a disability and mental health and stress, mental health problems can be disabilities just as much as any kind of physical limb difference, ME, MS kind of problems would be. The definition of a disability under the Equality Act is that it has a significant impact on your day-to-day life and that it's been happening for over 12 months. And there are some exceptions to that 12 months, for example, if you're cancer diagnosed. Okay, so you're already registered disabled. So it's not that your employer can't sack you for being on long-term sick. It's that they would have to be very careful about legally doing it because you are also disabled. So basically the bar is much higher for disabled people to be sacked for things related to their disability. So if, for example, if you have a disability and your employer's treatment has made it worse, and now you're on long-term sick, and they're now trying to punish you for being on long-term sick, then what I would do personally, Katie, is I would look at I've got a video series on YouTube or on TikTok called the 6 Types of Discrimination. So there are 6 types of discrimination. 2 of them are specifically only for people with disabilities, and all 6 apply to people with disabilities. And so I would look in particular at the discrimination arising from a disability type. I spoke to an employment tribunal judge, and he said, actually, often that one gets overlooked, but it's one of the more easier ones to prove. So it's basically your employer treating you badly because of something linked to your disability. So for example, I have ADHD. That's a disability of mine. And if I was in a workplace, I would always be late because I am always late. So if the employer sacked me because I was always late, but they knew about my ADHD, we were trying to work around that, that could be discrimination arising from a disability. Or, if you've got a back problem and they want you to ride the bus, but you can't ride the bus because of your back problem, they're not dismissing you because you have a back problem. They're dismissing you because you can't ride the bus, which is linked to your back problem. So that's what discrimination arising from a disability means. So I would look at that. The short answer is I would look at the criteria for dismissing someone with a disability because the criteria is much higher. Okay, so more questions. Oh, I'm very pleased to hear that's helpful. You're very welcome, Katie. And again, for you, Katie, and for others, the free action toolkit on my website will help you understand kind of what your options are in terms of grievances and things like that. So basically, it's like, somebody asked me a little bit earlier, what is the process? I'm sorry, I haven't answered that yet, but I actually have a 2-page PDF that explains the process. If you go to my link tree, the link tree will be in my bio on YouTube as well. You'll see like a free, it says free tribunal map or employment something map. Click on something that says map in my link tree. That will talk you through the whole process of starting with the bad thing happened, going all the way through the steps that typically happen and how a tribunal kind of unfolds and a few of the twists and turns that it can take as well. And we also have listed on that map where VALA has services or parts of our platform that you can use where they would fit in. So it's like, oh, I'm in this stage. Here's what I should be looking at on the VALA platform. Yeah. Lottie says, I have a question about grievances, but it's quite complex. Lottie, you can email us. If you email hello@vala.uk, the link is in the bio, or just hello@vala.uk. Then one of our team, we have a lovely team who pick up the inbox there and can answer your question. Right. So Vibrant Vibe, let's come back to that outrageous thing that someone said. Vibrant Vibe says he is complaining about the numbers between his nationality and other nationalities differ too much. The majority of the colleagues are upset and the company does nothing. Most of the colleagues are thinking of leaving due to daily harassment. Yeah. That is almost certainly not okay. And specifically, so I mentioned the 6 types of discrimination. One of the types of discrimination is called harassment. And in the Equality Act, harassment has a very specific meaning. There's sexual harassment, which unfortunately I think we all know about. But then there's also harassment, which is essentially bullying because of a protected characteristic. So in this case, the characteristic is nationality, and that is one of the protected characteristics. Race and nationality are a protected characteristic together. And so if someone out there is creating, some of the words that they use in the law is a humiliating, degrading, offensive environment because of a protected characteristic, then you don't even actually have to be a member of the nationality that he's complaining about to actually raise a grievance and say, look, I am being harassed here. And if you do that, not only do you have a potential legal claim that they need to deal with, but you have also done what is called a protected act. And if they punish you for raising that as an issue, then that's called victimization. And it's one of the other 6 types of discrimination. And it's also totes illegal. So it sounds like your company could be landing themselves into some seriously hot water by not dealing with this guy and his weird nationalistic rants. And the first step would be a grievance. And all of you could do it, or just one of you can do it. And even if you're not a member of the nationality that he is complaining about, then, or the nationalities that he is complaining about through omission by saying that not enough of his nationality are represented, it doesn't matter. You don't have to be the person being discriminated against to be offended by harassment going on in a workplace. And if you want to know more about that, see my 6 types of discrimination video series on TikTok, and that will talk you through, look at the harassment one specifically, and that'll give you some more information. But remember, for you, harassment and victimization could apply. I hope that answers your question. Casey says, it's strange when you come across severe bullying at work. It seems to hit home, and it's brave to stand up, and you keep standing until the case is all over being well. Yeah. It's like bullying at work. There is some bullying at work is hideous, and there is other bullying at work. It's all hideous. Some of it is illegal, some of it isn't. That's the part that really pisses me off. Okay, right. So Bold, I'm so sorry I haven't gotten to your question. I'm just trying to. Okay, so Bold says, I've just been let go after a new company has taken over after 10 years of employment. Okay, good. First question, Bold, were you too paid over? They're saying due to financial structure, that's why you were let go. I was a part of management. They have offered 1 month's pay. Okay, so Bold, how long did you work for the company before? Okay, 10 years, 1 month's pay. So if they're letting you go because of changes, that would be, it sounds like they're making you redundant, and it sounds like you should have 10 years continuous service, and you were too paid over. So how is that not 10 years continuous service? And in which case you would get, I can't remember, but I think it's at least a week per month or a week per year. So that would be 10 weeks of redundancy pay. They have said it does not apply. Why? Why doesn't it apply? Have they said why? So I know that there is a kind of, you can acquire a business. So do you have a new contract? Did they give you a new contract? Or are you still on your old contract? What happened to the contracts? As they moved me to another site. Yeah, but what happened to your contract? I mean, they can move you, but they can't. So they gave you a new contract. So Bold, I don't know the answer. I still think that they're trying to do silly shenanigans here, and that I would be very surprised if the 10 years didn't still apply. Have you phoned ACAS already to ask them about this? That's my first question. Yeah, it sounds like they issued a new contract to try and work around it. They can, I agree, Zen. They might have issued a new contract, but that doesn't mean that you magically You have not. Okay. What I would do, Bold, first thing I would do is I would phone ACAS and ask them about this. And let me just see. This is what I'm wondering. Is it a fire and rehire? Did they terminate your previous contract? But they said that you two paid over. If it's a two pay, it's not a fire and rehire. Two pay. No, you were not fired. Sorry, I asked too many questions at once, so I don't know which one you're answering. I was two paid. Okay, yeah. So if you're two paid over, then you should have continuous service. Okay, so Bold, two suggestions. One, phone ACAS. They're good at this kind of stuff. They will help you understand. Two, if you do want our support, the merits assessment service is the right service to get from us. So if you do decide that you want support from us, we can talk you through that. But I do think ACAS might be able to support you. Flumpy might be able to support you as well. Go for it. I can look up the specifics here, but it's a little complicated when I'm talking to people as well. And sometimes I can't remember all the details. Right. This happened today. Okay. Well, first of all, Bold, I'm so sorry. You're still dealing with it. I'm so sorry. Definitely phone up ACAS. You can still phone them right now. ACAS helpline. I think they're still open. Let me just get the number for you. Okay, so let's get the number. I'll make sure they're still open. Yeah, they're open until 6 p.m. Okay. Here's the details. Bold. So they're open until 6 p.m. and there's the 0300 number. Call them and talk to them first. Please do feel free to come back. And once you know a little bit more from ACAS, this is going to really rely on the contract that you were given. The specific details of the two pay. So if you can phone them up and speak to them, that would be able to help. Okay, what would happen if you win an employment tribunal, but they can't afford to pay you? If the company goes insolvent, you can't do a voluntary liquidation as a company if there are any debts owed. So for example, if there is you're very welcome, Bold, and I'm so sorry that happened to you. So if the company went insolvent, but there are debts to pay, then an administrator would have to be appointed, and that administrator would then look at all the creditors and do their best to sell off any remaining assets to pay those creditors. So you would be amongst that list of creditors if the company was insolvent. If the company just doesn't pay you, then they went into voluntary liquidation. So they're not. If they had a debt to you, then they can't go into voluntary liquidation. And you can involuntary the liquidation. You can go to the company's house website and say, no, they actually do have a debt to me, to involuntary liquidate their company, basically. So if there is a debt outstanding, then you can essentially stop the liquidation and make sure that your part is actually getting covered. Does that answer your question? Casey says, check who pays you. Is that a website, Casey? Let's see what they say. Okay. Right. Can an employer... so Zen, you had a question, but you said it was a little complex. Zen, you can email us, hello@vala.uk. Hello@vala.uk, and one of the team will have a look. What happens if they're a sole trader and they can't afford to pay you? It's a good question, and I don't know. My case has gone to the directors directly. If I win, would they have to pay? Did you list only the directors as the respondents, or the directors and the company as well as the respondents? If the company was listed, then the company liquidation stuff would be all. In that case, I think even as directors, they would still be directors of the limited liability company, which would probably mean that it would still go into the liquidation cycle. Is this actually happening, Amanda? Have they, do you have a claim against them that has won and now you're waiting for the money, but they've gone into liquidation? Okay. There is a website. Let me just see if I can quickly find it. Okay, I can't find it just now, but there is a website out there that basically gives you instructions on what to do. I will see if I can find it and do a video, or let me just follow you. If you want to follow me, I'll just try and follow you. Cool. If you could just DM me, I'll see if I can find that website and send it over to you. It'll be sometime this weekend when I have a second, and I can see if I can find it for you. Okay. Right, here we go. I have messaged you. That's great. Hale, if you've messaged me, please do it on hello@vala.uk. The link's in the bio, and you'll get a much faster response. There's only one of us who really looks after the TikTok DMs, but there's like a whole team that looks after our email inbox. Any tips for judicial mediation? Good question, Angel. Good to see you, Angel. Judicial mediation is basically all written down instead of verbal. So basically you put together everything and then the judge reads it and then makes a decision. So with judicial mediation, even more than regularly, you want to make sure that you are making your case as clearly as possible in writing. So the documents, like the statements that you're putting together, make sure that that is as solid as possible. Whereas if you're in the open tribunal, yes, you have a witness statement, but you do have that cross-examination opportunity. But if you, because you don't have the opportunity for cross-examination in a judicial mediation situation, you need to then think about how to make your points without that particular point. So you need to make your points clearly outside of cross-examination. So for example, in a cross-examination situation, you might have said, for example, did you know that I was pregnant before you sacked me? And they might say no. And then in a cross-examining situation, you'd say, well, can I refer you to page 57 of the bundle? And they would look at it and they would say, is this an email that says Angel is pregnant? And they would say yes. And they say, and who was the email addressed to? And they would say, oh, it's me. You say, so you did in fact know that I was pregnant before. And what was the date of the email? 12th June. And what was the date that you sacked me? 14th June. So you did then indeed know. So it's kind of like the Perry Mason stuff, you know? That's what you can do when you have cross-examination. But in judicial mediation, you don't have that. And so you need to make clear, hey, Allegro. So you need to make clear in that example, on this date, this thing happened, on this date, that thing happened, and therefore they did know. So that's the difference between the two, if that makes sense. Danae, the NHS cannot settle cases without Treasury approval, so it can only go to ET. All that requires, it further defers employees with strong cases. That's a good point, Casey. So it is different in the NHS, and I need to do a few more NHS cases just to make sure that I'm completely boned up on it. But yeah, I know the NHS grievance process, it's all the levels and things like that. If they can't do a settlement, then you end up having to go to tribunal because they can't do it any other way, which is ridiculous. Again, ridiculous. You are very welcome, Angel. Would your team be able to help me with my issue? I have no idea where to begin. I'm so sorry that you're dealing with that, Kieran. The first thing I would suggest that you do is go and download the free action toolkit in my bio. That will give you a lot of details about where to start. And our team are wonderful, and typically we get involved past the grievance point. So if you filed a grievance onwards, that's where our team can kind of really sit down and work with you. And the first thing, if you're in that kind of, if you filed a grievance, it's not going well, then you could look at our merits assessment service. It's in the link in my bio, merits assessment, and that's where we'll kind of talk you through should I keep going with this? Is it worth it? How much might it be worth? All that kind of stuff. And then you can kind of go from there. I finally bought coaching today. Oh, Allegro! That's wonderful. Oh, wonderful. I can't wait to see who, we've got a few new coaches as well who are awesome. So I can't wait to see who you end up working with. That'll be so good. Is dismissal without any warnings allowed for 6 months sickness? Michelle, oh, Michelle's so good. She's new and she's great. Is dismissal without any warnings allowed for 6 months sickness without giving warnings? Not without giving warnings. Well, if you've worked for under 2 years, if you've worked for over 2 years, then that's different. Well, sorry. If you've worked for over 2 years, a dismissal without warning, pretty much under any circumstances outside of gross misconduct, would be bad. If you've worked there under 2 years, and a dismissal without warning about sickness that is related to a disability would be bad. Right. Does the remedy get higher with more examples? Andrew, I will come back to you. Does the remedy get higher with more examples? I.e., does 4 proven cases of victimization equate to more than 2, for example, recompensation? The more, the better. Good question, Casey. So, if you're talking about injury to feelings, then the way the injury to feelings is calculated, which is the main compensation for discrimination outside of past and future losses, is the impact that it had on you and the severity of the thing that happened. So, for example, there are 3 bands in the injury to feelings award. The top band, the example that the case gives that says this is the most severe, it described an ongoing campaign of harassment as the example. And the bottom band, the least serious cases, was described as a one-off incident. So in that way, if you can prove multiple incidents of what has happened, then it could increase your potential injury to feelings award and bring you into a new band. But you also, injury to feelings also, you have to prove that it did injure your feelings. For example, you were signed off, you had depression, you had to take medication, you had sleeplessness, it affected your personal relationships, etc. So the duration of what happened, the number of incidents that happened is part of it, but the key part of injury to feelings is the impact it had on you. And if you do want to know more about that, we did do the injury to feelings webinar recently, and that just became available for you to download or watch. Let me just get the link and I'll pop it in both cases. So it's £12 to download or to watch the webinar back. There's loads of good information in there. Samira gave us a lot of great examples about how to prove it and things like that. So here is that link. Very welcome. And here is the link for TikTok. Okay, great. Andrew. Let's go back to your question and make sure I haven't missed it. Okay, so I was fired because I failed my probation period. I got 1 point on everything. Yeah, I was never late, never had an organized leave, but I had 1 unauthorized leave, but I had 1 unpaid holiday, and I have no idea how customer service was a 1. Then I heard from a third party that it could have been because they didn't need me as there was too many staff, which I know ain't allowed, so they lied on my probation. Andrew, also are you able to read my okay, and also my firing was an ambush. So it sounds like you're there under 2 years. Oh, can't open this link. That's weird. Can anybody else open the link, or is it just Pathan? Oh, it's because of the TikTok annoyingness. Actually, Pathan, even easier. Click on the link in my bio, and then you'll see it's the top link on my link tree. So I worked there for a month. Okay, so you were there for a month. You were in your probation period. So when you say they can't do it because they didn't have enough people, what do you mean by that? Or they weren't allowed to do it because they didn't have any work for you? It sounds like that's where you think that it was illegal. Is that right? I'm not aware of that one. That's the reason why I'm asking. KC says, I think, so we're talking about the injury to feelings and multiple incidents. I think in general, there's bound to be more than one or two examples of misconduct if the prohibited conduct is targeted, etc. In many cases, absolutely, yes. So in many cases, yes. I have seen one-offs. In like sometimes that's enough, and maybe they're dismissed after that one-off or something like that. But in many cases, you do show a long history of conduct, which is why a lot of injury to feelings cases end up in the middle band. So apparently they had hired more staff than they needed. This is in Scotland, so I'm not sure how the rules differ to England. Okay, so I'm in Scotland too. I'm not saying that there's not a rule that says that you're not allowed to hire people if you don't need them. I just don't know what that law is, if that makes sense. I would phone, because I don't know, I would phone ACAS and ask them. They're even open now for the next hour. I just gave somebody else the link. So I would ask them about that. Can you hire, it sounds like the question is it legal to hire someone if you know that you don't need them? I'm not aware of that. I'm not aware of it. So I'm sorry. I'm so sorry I can't help you, Andrew. Okay, so Python. I'm going through, by the way, Python, awesome movie. Loved you in Python. I'm going through a second preliminary hearing. So sorry, Andrew. Cool. Let's see. So Python is going through a second preliminary hearing. Let's see how can I help you with that second preliminary hearing? Sammy, do you have any advice on raising the issues with the Bradford scoring system to a workplace? The Bradford score is so annoying. Hey, Frodo, good to see you. So, okay, so cool, Python. What do you want some help with the preliminary hearing? What is the preliminary hearing about? How can I help about the preliminary hearing? So I've already forgotten the other question. Oh, the Bradford score. Sorry, sometimes I get a little lost. Do you have any advice on raising issues with the Bradford score system in a workplace? Yes. So for anybody who doesn't know, the Bradford score is this weird scoring system that basically says if you have more than X days off in a given time period, then that is bad, and it means that you could be at risk of additional kind of scrutiny and even get dismissed because you have too many days off. Fundamentally, your employer can't rely on the Bradford score if you have a disability. So if you look at the legislation, it's section 20 and 21 of the Equality Act, which is about a failure to make reasonable adjustments. The failure to make reasonable adjustments is that your employer has to make adjustments for you if you have a disability. And there's 3 ways that they can fail that. One is if they fail to change a PCP, which is a provision, criterion, or practice. So if they fail to adjust a provision, criterion, or practice reasonably for you. The second one is if they don't make physical modifications. And the third one is if they don't provide auxiliary aids. So that first one, that PCP, provision, criterion, and practice. So if they basically say the Bradford score is the way it is and there's nothing else, they have to be able to look at that Bradford score and say, okay, well, Sammy has this X disability. What reasonable adjustments can we make to the Bradford score? Because every person with a disability is unique, and obviously we need to make accommodations for that. They can't just say, nope, that's it. That's the policy. Too bad. That is literally the definition of a failure to make reasonable adjustments. It was recommended to have more lenient sickness policy in my occupational health, but they said it is not needed. See, that is the textbook definition of, it's literally section 20, paragraph 3 of the Equality Act. That is exactly what they are skirting on very thin ice there about. And so if you want to raise this as an issue, I think I would raise a grievance with section 30, section 20, paragraph 3, and say, I fear that you are relying on a provision, criterion, or practice that is not, you're not making reasonable adjustments to this PCP, even though occupational health suggested it. I think they would really struggle to justify that in tribunal. Yes, do take it. And remember, Sammy, when you raise this, what you are doing is called a protected act. Because when you complain about potential discrimination at work, then you are, this is assuming, yeah, so when you raise this, you are doing a protected act. If you say, I think that this Bradford score is discriminatory to people with disabilities, that is like a magic phrase. It's a magic phrase. That is a protected act because you said, I think discrimination is happening and I think it's because of this protected characteristic. Those two ingredients make the magic of a protected act. And once a protected act is uttered, I would write down that you said it. I would keep notes that you said it or write it down in writing. Then if your employer treats you badly because you said that, and that link has to be there, they have to do it because you said it, then that's illegal. That's called victimization. So you've got two fronts that you want to think about here. One is if you have a disability and they're trying to use the Bradford score without making reasonable adjustments to it, then that is potential failure to make reasonable adjustments. That is one of the 6 types of discrimination. If you then make that protected act and they punish you, then that is another of the 6 types of discrimination, victimization. Does that make sense, Sammy? And yeah, Christian, so Christian, the reason I can cite down to the paragraph, Christian's over here on YouTube, reminding me is because, Christian, we were just looking at your email today, just double checking our understanding. So remember I said there are 3 things that can mean that they're failing to make reasonable adjustments. There is a PCP, the provision, criterion, or practice. There is physical changes, and then there is the auxiliary aids. So if they don't provide any one of those 3, depending on what you need, then that would be a failure to make reasonable adjustments. So look at all 3 paragraphs. To me, it sounds like the PCP might be the one because it's the Bradford score. That sounds like a PCP to me, but remember there are all 3. And thank you for pointing that out, Christian. I'll make sure that people know about that in the future. And Christian, since you're here, I did check. Our claims builder on VALA includes both sections 20 and 21, and we do list all 3 tests in our claims builder. So thank you for checking on that and making sure that I checked that so that I made sure that we had all 3 available for people so that they know that that's what could apply to them. So I appreciate you. Okay, I think I'm gonna go soon because I'm starting to get overheated. But let me just see if I can do a few more. It's always very intense and fun talking to all of you. Oh, Brass Monkey has a follow-up question on this. Hi, if instead of saying a protected characteristic or disability, if you were to say a sickness absence, would this be covered? Brass Monkey, a protected act only applies in discrimination. There is also something called a protected disclosure, which is to do with whistleblowing, but that's not related. A protected act is only for discrimination relating to a protected characteristic. If the sickness absence that you're in relation to is in relation to a disability, and keep in mind, mental health problems also very much qualify as potential disabilities. You just listed, like, depression is just as likely to be a disability as ME. So if the sickness is related to that, then it would still be the protected characteristic of disability, but it does have to be a protected characteristic that is named. I have actually heard an HR person in a review say the disability is not real because it's mental. Like, what the hell, guys? Like, what the hell? That is so patently not true. That is so patently not true. No, mental health problems are, there is no distinction in the Equality Act between physical and mental health problems. The definition of a disability says that it needs to be something that has an impact, a significant impact on your day-to-day life and has been happening for over 12 months. And there are some cases like cancer and things where it doesn't even have to fulfill the 12 months. But mental health disabilities are disabilities. ADHD, dyslexia, depression, anxiety, all of those have won tribunal cases. Absolutely. Do you need to quote the sections? No, you don't have to quote the sections. It's just you need to know the sections. I mean, I would specifically read the Equality Act. It's readable enough to understand kind of what's going on, but you don't have to quote the sections. You can just say, I think, like a protected act could be as simple as, I think that this policy is discriminatory to disabled people. That can be a protected act. Equally, I think our hiring process does not help people of color or is discriminatory to people of color. That would be another protected act. Okay, a few more questions. I love how passionate you are. I am very passionate. It's just like, it's so, I just wish everybody knew about this stuff, because if everybody did know about this stuff, we would have so much more accountability, like so much more accountability, and people would be able to, like, if the accountability was there, then employers wouldn't think that they could get away with half of what they get away with. And that's really, I often describe Vala as a accountability machine. Vala, you are a legend, and welcome in the Shire anytime. Thank you, I appreciate that. Kate says, I'm like this, I'm with health and safety, that's what I do. Yeah, you totally get it, Kate. Okay, so let me just scroll up a few more, and then I'm going to go soon. But do I have any resources in continental Europe similar to Vala? I'm afraid I don't, thumbs up. I'm so sorry. Can I get your help, user 126? Yes, you can, user 126. If you have made a grievance kind of onwards, our merits assessment service might be the right option for you. It's in the link in my bio, or it's on our website. But if you go to our website, vala.uk, then you can go to coaching services, and then if you just go to vala.uk, there's 3 options on the homepage. Pick the one that feels right for you. Is it discrimination classed as gross misconduct led to Billy? Okay, hold on. Can you help writing a statement for my disciplinary hearing? Mousy, we have a template that can help with a disciplinary appeal, but a statement for a disciplinary hearing, you know what I would do, Mousy, is the short answer is I don't have anything immediately to just give you. But what I would do is, if you go to, there's a few videos back on my TikTok. There is a video called How to Prepare for a Grievance Meeting. A lot of the advice is going to be the same, because what you want to bring into a disciplinary meeting is a timeline of who, what, where, when. So what have they accused you of? And what is your evidence? So the more you can lay out everything that happened and the who, what, where, when, you know, who said what, where were you, when did it happen, etc. And you can use our platform to kind of lay that all out in the timeline section, or you can just, you know, put it in a Google document, whatever. But that's my number one tip for both disciplinaries and grievances. Go into those meetings with that who, what, where, when, because that's the information that they're going to ask you for. And the other tip I would give you, Mercy, is go to the ACAS website. They will have instructions for what you are expected to do at a disciplinary meeting, and we'll probably have some information about how to write that statement as well. Okay, Lottie, I can't remember if I covered. Can I ask you a question via inbox? You absolutely may. So Lottie, if you just email us, hello@vala.uk, one of my team will pick it up. They are lovely. They're very qualified. They're very good. Okay. Okay, so without a grievance outcome, 4 months on, and my conciliation time is running out next week. So far here, in that case, it sounds like you might want to file a tribunal claim if you want to maintain the option of going to tribunal. We have the ET1 template that can help you with that. It will help you write the particulars of claim for the ET1. So yeah, and one of our team will review it so if you write it, you can then submit it and one of our team will review it for you. So if you'd like to do that, you can, like, yes, we do. So Yes, is the short answer. So what you could do is I would purchase the ET1 template that will walk you through. It's not just a template, it's like a guide, and it will walk you through understanding your claims, doing some details there. You can get a draft together. Then we can do a review. And if you have any further questions, you can book some additional time with us via one of our tribunal coaching packages, and then they could give you some additional support. So I would recommend that. I would start with the ET1 template, though. Okay, I'm so sorry, but I'm actually quite warm, and apparently I've been going for a while now, so I'm going to go just now. There are so many questions. I'm so sorry that I can't answer all of your questions. Please do. I'm so sorry I can't answer everything. Please do email us if you have a follow-up question that I have not gotten to. So the link is in my bio. YouTubers, it's hello@vala.uk. I'll just put that in the thing. So if there is something else you want to know and I have not gotten to it, it's hello@vala. Oh, look at my little heart. Thank you. Thank you all so much for coming. I'm so sorry I couldn't stay longer. It was so nice hanging out with you, and I will be back. And in the meantime, like, look after yourselves. I'm so sorry that you're having to deal with these issues. It's not fair. And look around you. Look how many people there are here. You're not alone. You're doing a great job. And I will be back to answer more questions later on. Thank you all so much. See you soon. Bye.